Good afternoon, everyone. Judge Rivera will be participating remotely in oral argument today, and the first appeal on today's calendar is appeal number 35, the people of the state of New York versus Wilkins. Counsel?
May it please the court, may I reserve 2 minutes for rebuttal, please?
2 minutes, sir?
Please. Mr. Wilkins did not impliedly waive his Anta Mari rights violation when the court first failed to clearly inform him that there had been a violation of his right to be present at the sidebar conferences already conducted. Second, failed to tell him that the options with regard to that violation were for the court to either declare a mistrial, conduct de novo conferences, or for Mr. Wilkins to waive that violation retroactively, and where the court failed to make any inquiry of Mr. Wilkins regarding that violation, what his choices were with respect to those options. The vague statements by the court and prospective-only questions do not provide a basis for this court or any court to find that Mr. Wilkins knew that he was being asked whether he wished to waive retroactively the violation of his right to be present at those conferences. The burden was on the court that had first violated Mr. Wilkins' right to be present at those conferences, and then was told that by the DA to inform Mr. Wilkins of that, and again to inform him of his choices and elicit a response, elicit a choice. Even with respect to the prospective-only question that was asked of Mr. Wilkins, he reserved his right to decide on a case-by-case basis. It was not a blanket waiver going forward, it was not a waiver at all retroactively. The people argue that the failure to object constitutes an implied waiver. The reason that this court has repeatedly rejected an objection requirement in Anta Mari cases, despite the fact counsel presumably always knows the relevant law, is that the right to be present involved is both fundamental and personal to the defendant. Therefore, this court, over 30 years, or almost 30 years, 29 years.
Mr. Schifrin, in an Anta Mari case, an implied waiver there is such a thing as an implied waiver. You understand that?
Absolutely.
All right. And when does an implied waiver apply? What's your understanding of the law, and when would it not apply?
The two cases that I found with implied waiver of the right to be present from this court are People v. Spotsford, cited and relied on by the people, in which first there was an express waiver of an Anta Mari hearing, but more importantly, relevant here, after the hearing, the court expressly invited an objection, and there was no objection. So unlike this case, Mr. Spotsford was made aware of his choice, and by his silence, it's clear he chose not to object. Similarly,
I'm sorry, did you go ahead? No,
Does
go
the
ahead.
language that the court used after, I'll read the whole sentence. As to the 4 separate bench conferences, the defendants remained at the counsel table with the prosecutors and defense attorneys present. Is that still the intention of each of the clients? How does that language impact?
I think the reasonable reading of that language is the court is asking prospectively, are you still intending to stay seated? Given the fact that it's undisputed that Mr. Wilkins was not informed before these 4 sentences by the judge, and before the DA pointed out the error that he had a right to be present, that language cannot be reasonably read as requesting of Mr. Wilkins what his decision was with respect to the conferences already conducted. It was easy. The court was asked by the prosecutor, please inform Mr. Wilkins of his right, or the 2 defendants actually, of their rights, and seek a waiver. Rather than do that, rather than clearly inform them there was a violation of a right already occurred, give them the options, and ask for a decision, the court engaged in that, what I refer to as vague language. The Fourth Department, in reversing the co-defendant's case, called that vague language. To find an inferred waiver based on that is very different than Spotsford, where again there's an express invitation for objection. The only other case I found with an implied waiver of the right to be present is Flynn, where again Mr. Flynn was told he was welcome to attend conferences, and he chose not to attend. He was made aware of his option, and his action reflected a decision.
Counselor, I understand that it was easy and it should have been easy, but that's not the situation we have here. So now we have a situation where the juror is still in the box. In fact, the juror is questioned after the Anta Mari, right? They're questioning her. They're engaging her. She's in the box. She hasn't left the threshold of the courtroom. Had she left, I would agree with you. But now she's there, subject to questioning, subject to putting things on the record, subject to going back to sidebar. Does that alter your analysis at all?
It doesn't, for a few different reasons. First of all, again, Mr. Wilkins was never advised his personal right to engage with respect, we're referring now to juror CK. More importantly, he wasn't present to observe the demeanor and actual tone, etc., of CK during that sidebar conference. He was excluded from. This court has repeatedly, and there's cases cited in our brief at pages 15 and 16, that repeatedly talked about the importance of the personal observation of the defendant. He was deprived of that. He was deprived of that, again, through no fault of his. He wasn't informed by the court. This court, through the Anta Mari cases, has made it the court's responsibility, not counsel's responsibility, to make sure a defendant is present unless there's a waiver. That didn't happen here.
I understand that. My only concern, again, and what I'm struggling with, is the fact that she was still there. The defendant would then have an opportunity to gauge, her disposition, to hear her. He's aware now of Anta Mari. His attorney is aware of it. The attorney is actually questioning her when she's in the box. She hasn't crossed that threshold outside the courtroom. Are we to say that doesn't, that to sit silently is something that we condone once all the factors are present to make a change in this situation? Under these facts, I understand what you're saying generally, but in this situation, when she's still there.
First of all, this defendant doesn't know the defendant, Mr. Wilkins, doesn't know he's allowed to do anything. He's never told, you can speak. He's never asked his opinion, etc. So there's no gamesmanship on his part. because he doesn't know that there's a Anta Mari rule that's reviewable absent objection, absent showing of specific prejudice. So the personal right of the defendant, which is what Anta Mari is about, clearly there was no gamesmanship by him. But in terms of the knowledge, the court presumably knew all that. In this case, not just presumably, was told this by the prosecutor. So there's no reason to find cunning actions by counsel and yet naivete by the court. Having been told by the prosecutor, gee, you should tell him, basically, we screwed up. Can you tell him his rights and seek a waiver? The court did not do that, did not clearly explain there was a violation. The court did not clearly seek a retroactive waiver. The onus with respect to Anta Mari has, for all these years, has been on the court, not on defense counsel. That's why there's no preservation requirement. Rather than now retroactively, rather than now creating a new objection requirement and applying without notice retroactively to a case tried 4 years ago, the simple rule should be, we have a clear rule with Anta Mari. It's easy to follow. We know that because there's only been 8 Anta Mari violations, reversals this century, okay, and including that of the co-defendant in this case. If in a rare case that a court is made aware that it made a mistake, the court should then be obligated to correct itself. It's not an obligation on the defendant or the counsel. Counsel had reasonable reliance on this court's jurisprudence that he has no obligation or duty to object. To impose an obligation on the counsel to object when we've been told through many, many cases there is no such obligation is fundamentally unfair to Mr. Wilkins. There was reason to be able to rely on this court's prior rulings.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the court. Your Honors, it's well-settled law that a defendant may waive their Anta Mari rights, and that is precisely what happened in this case. Going to appellant counsel's last point, the people are not seeking to impose an obligation on a defendant to affirmatively assert their Anta Mari rights. Again, case law is very clear, there is no affirmative obligation to do that. What the people are asserting under the facts of this case is that when a defendant does take actions, those actions can constitute an implied waiver of their Anta Mari rights. And in fact, going to Judge Fahey's point, when you really consider Anta Mari waivers, every Anta Mari waiver is a combination of an explicit waiver and an implied waiver, which is no different than what happened in this case.
You know what I wonder about is it's Mr. Miles, right?
Yes.
Yeah, Mr. Miles, would you see any difference between your argument for an implied waiver under these circumstances, because there are circumstances in Anta Mari jurisprudence where an implied waiver is allowed, but under these circumstances, is there any difference between this type of an implied waiver and a preservation rule requiring you to object? Whether you know about it or not, sometimes things have to be preserved and you have to object. Here you're saying, whether you know or not, it seems you're saying you have to object, which is just another way of saying you got to preserve the objection.
I understand your point, Your Honor. However, it is a fine distinction, but it is a distinction.
Tell me what the distinction is,
Yes.
as you see it.
Yes, Judge. Had the defendant done nothing when it was brought to his attention that that Anta Mari had not taken place, that the Anta Mari waiver had not taken place, had he done nothing, there would be an Anta Mari violation. But by taking affirmative actions, by stating that he wished to continue not going up to the bench, that he understood his Anta Mari rights at that point.
But he didn't really say that he understood his Anta Mari rights.
Fair enough, Your Honor, yes.
Right.
He didn't explicitly state he understood his rights, but he did assert that he wished to continue as he had been.
You know,
sitting
it's
at
an
the
interesting thing. These are essentially fundamental constitutional rights. And it seems that your analysis would rely on a really subtle and thinly sliced reading of the conversation that took place between the defendant and the bench. And I'm wondering if you think it makes sense for us to rely on that that kind of a reading and preserving sort of a basic, not sort of, a basic constitutional right?
Well, Your Honor, again, it's clear that this basic constitutional right is a waivable right, and it is one which is waived in the majority of trials.
Sure.
And most cases that make it to this courtroom rely on a fine parsing of the facts of the case as it relates to established law. So in
Counsel,
that-
I'm sorry to interrupt you, but
Yes.
just on this waiver issue and the constitutional right, I thought we said in Vargas that significantly the right to be present at sidebars is not rooted in the Constitution, but rather in CPL 26020.
Yes, Your Honor.
So are we talking about a constitutional waiver here, or are we talking about a waiver of 26020?
There are cases which discuss it in both contexts.
But
There are
Vargas
cases-
was a waiver case, wasn't it?
It was, Your Honor. I think people, I believe it was People v. Roman, which made the distinction that the right to be present at sidebar conferences, while the sidebar conferences do represent material stages of trial, that it is not a core function of the trial, it's an ancillary proceeding. So in that sense, I would agree with you and the Vargas court, which stated that it is a statutory right. And again, in that sense, I believe you have to look in each individual case where there is a waiver, you need to look at all of the circumstances. And again, this is a very unique case. The circumstances here are, as far as I'm aware, a case of first impression, where the specific facts.
Let me ask you
Yes.
something. So the appellate division, as I read it, decided the issue regarding juror CK on the ground that the trial court had split the peremptory strikes, and that's the basis of the dissent in the appellate division from Justice Curran as well. They didn't decide on waiver, and you're now asking us to decide on waiver. Why doesn't LaFontaine prevent us from doing that?
Because the appellate division never touched on that. That was argued below at the appellate division, and they never addressed that in their decision. They never addressed that either agreeing with it or disagreeing with it. They didn't address it either way. They said, they simply decided the issue on the grounds that the defendant could not have had any input at that sidebar, and so there was no violation.
But then you're
And they
asking
left
us
it
to
at that.
affirm on a different ground than the appellate division affirmed.
That's correct.
Was there ever any attempt in this trial to reconstruct a sidebar conference, the sidebar conference?
No, I don't believe there was, Your Honor. There was never any request for that type of remedial action by either party. And going back again to just the general world of antimarchy waivers, every antimarchy waiver, rather the typical antimarchy waiver, is an explicit verbal waiver at the beginning of trial.
But you
However-
can impliedly by action, a waiver antimarchy rights. Of course, that's when you know that you have that right.
Correct, Your Honor, and which is
You
why-
wouldn't disagree that he didn't know at that point that he had that right. No one had told him that.
At which point, Your Honor?
Well, at the point that the language that was quoted by defense counsel before, that reading of that language itself. Is there any proof in the record that says he knew that he had an antimarchy right then?
Prior to the point where the court informed him of his rights, no, there's no indication that he did, which is why we need to look at his actions at that point and going forward from that point.
Well, it's just, I'm sorry, go ahead, Counselor.
So, counsel, I'm sorry, I'm on the screen.
Rivera.
Let me ask you this. If indeed the judge, if the record was clear that the judge said, moving forward, you can come up to the sidebar, you have this right, you would agree then that he has not implicitly waived the prior right or otherwise somehow abandoned his objection to the prior violation, correct? Because the court is focusing prospectively. You would agree if it's obvious that the court is informing a defendant about a prospective right, that one shouldn't take any statement or action to refer to a retroactive waiver? Or do you see it differently?
If the only thing we had to go on was the language of a court making it clear that it was a prospective only right, if that was all we had to go on, then yes, I think we would be constrained to agree that that could not in any way be considered an implied retroactive waiver. However,
Okay, so then if that's the case, if the record is ambiguous and unclear, why wouldn't we read it as not a waiver?
because there is more that we have to go on than just the judge's words. However, the judge's words are indicative of, again, that language of, do you wish to continue what you have been doing? Do you wish to continue not coming up? That indicates that they are looking backwards in time. And the defendant's words and actions going forward from that point indicate that there was a waiver for the sidebars that had already taken place. So we do not just have the judge's words in this case. We have the judge's words, the defendant's words, and the defendant's actions. I see my...
Well, the defendant's words are that I'm going to take it one case at a time. It's not a blanket, yes, moving forward, I defer to my lawyer, right?
That's correct, Your Honor. However, which is why I stated that you have to look at not only his words, but also his actions, and the fact that he did, in fact, stay seated for multiple sidebars going forward from that point. Finally, Your Honors, should the court find that there was not an implied retroactive waiver, it would be the people's position that this is precisely the kind of de minimis violation that the court recognized in People v. Roman does not require reversal.
Thank you, counsel. Counsel, your rebuttal?
Very quickly, first, the statutory right involved here has been referred to repeatedly by this court as fundamental and personal, which is why this court has repeatedly held that no objection is required. The second, and sort of following up with the questions from Judge Rivera, the problem here is twofold. One, there was the initial violation of my client's rights, but when the court was informed of that, the problem is the failure of the court to make clear to the defendant both that his rights were violated and what his options were. He was never, and having not been told of his options, he wasn't asked to select among those options. To now effectively say, well, you didn't do anything, even though you weren't clearly told you could do something, is to, in effect, reward a court for repeated violations of the right to be present. The Roman language just cited by the prosecution refers to cases as de minimis when the defendant's presence could not have made a difference. The defendant's presence could have made a difference here with respect to both prospective jurors, CK and CO. CK was excused because of a preemptory challenge announced by co-defendant's counsel, but under the statute, that's effectively announced by both counsel. There's nothing in the record that shows anything other than the statute was being followed here. The two defendants and the counsel met together after each round of questioning. In fact, the court said you have cumulative 20 preempts. Well, the opposite is the absurd result that we actually currently have, where the co-defendant's conviction was reversed because his attorney got to announce the preempt and Mr. Wilkins' attorney didn't, and the co-defendant's attorney was able to exercise 11 of the 20 preempts because he went first. That isn't the law. It's not what happened in this case. With respect to CO, CO was removed not for cause on consent, but on consent. In both People v. Danielson and People v. Roman, this court has reversed on Anta Mari grounds when jurors have been removed on consent. In Roman, this court made the distinction. In the jurors who were removed for cause on consent, there's no input possible for the defendant. But for the jurors who were removed in Roman for just on consent, was reversible error. Over here, CO expressed concerns with respect to the Greece Police Department, a police department not involved in any way or shape in this case. She was never asked whether she could be put those aside in rendering a verdict in this case. There was nothing about her answers demonstrating that she was incapable of rendering a fair and impartial verdict in this case. Therefore, she would not have qualified for a full cause challenge if one had been made. She was removed on consent. Both attorneys Both defense attorneys expressed their consent prior to the court removing her. So CO, who was removed, by the way, in answer follow-up to a question from Judge Singas, removed prior to any discussion at all about Anta Mari, was also a juror who was questioned outside Mr. Wilkins' presence, who Mr. Wilkins' presence could have made a difference.
Counsel, would the error have, Judge DeFiore,
I'm sorry.
Would the error have been cured had the trial judge invited juror CK back to the sidebar, included the defendants and their counsel? Would that have cured the error with respect to this defendant?
With respect to CK, yes.
And recreated that would have cured it?
With
Okay.
respect to CK, there's no question the case law allows for de novo conferences. And again, we urge that CO also was in the same category, but in any event, the problem was the court didn't engage in de novo conference, didn't grant the mistrial, and didn't clearly give the option. And finally, in follow-up to the question from Judge Wilson, I think there is a LaFontaine problem because, again, there was no decision on waiver retroactively with no fact-finding by the trial court in this case. There was no finding in Mr. Wilkins' case. As an aside, in the co-defendant's case, the Fourth Department affirmatively rejected the argument of waiver, saying that the record was too, what the court said was too vague and prospective-only questioning couldn't support a finding of implied waiver. And therefore, the basis for this court to make a decision on grounds not reached by the courts below is a LaFontaine problem.
Thank you, counsel.
Thank you.
The next appeal on this afternoon's calendar is Appeal Number 76, the estate of Kainer versus UBS.
Should we move forward, Your Honor?
You may remain right where you are.
May I have 2 minutes for rebuttal, Your Honor?
You may, sir.
If this case, Your Honors, were a case about the theft of a sack of potatoes in Switzerland, which was later sold on the New York potato market, there'd still be argument, but you'd have a much stronger case for a forum non-convenience dismissal. And to me, the most important thing in the whole case here is it's not a sack of potatoes case. It's a case about stolen art looted by the Nazis, and that should weigh very heavily in the forum non-convenience calculation, and there's no indication in the opinions below.
Counsel?
Yes, sir.
I'm having a little bit of trouble understanding exactly what you would like us to do with this case. So, one issue is, should they have gotten a personal jurisdiction finding on the record first before they got to the forum non-convenience argument? And to that, I think we'd have to, if we agree with you, send it back and have them do it, but it doesn't seem like you want us to do that. And then if we go on the forum non-convenience argument, normally what we would do, if they missed a factor, is undo that and send it back and have them do that again, and you don't want us to do that. So I'm having a little trouble as to what you'd like us to do.
Well, maybe, yeah, obviously I have an ideal result, and I have other results that I would ask for in the alternative, Your Honor. My ideal result is that you would determine as a matter of law, which is, I admit, an unusual case, but I think this is one, that they erred in granting the forum non-convenience motion, and on this situation, there was no alternative as a matter of law but to deny it. Obviously, if you don't reach that conclusion, then I would, yeah, it should be sent back, but I do think it's a matter of law. On the other problem you mentioned, it's obviously a very sticky one because I do think the court was wrong in reaching forum non-convenience, and I think that's quite clear under Ehrlich-Bober, which is a holding, not dictum in my view, but they did it, and they wrote, there are a couple of opinions out there, and the reason I have the ambivalence that you comment on in my brief is I am concerned about a catch-22, where they say, congratulations, you win. You get 2 or 3 years of discovery on jurisdictional issues, and then they say the forum non-convenience holdings before stare decisis, so I've been wasting my time. So I would ask that if you are going to go that route, that you at least make clear that the decisions that have already been rendered improperly on forum non-convenience and in violation of Ehrlich-Bober, that they are not precedent, that they are not stare decisis, that they do not bind anyone, and that if the courts below later reach the forum non-convenience issue, they do it on a clean slate without regard for the previous decisions. So I don't know if I've added to the conclusion or clarified it, but I do have that kind of hierarchy of preferences. Obviously, if you agree with me that as a matter of law, because of the inadequacy of the Swiss forum, the clear inadequacy of the Swiss forum, forum non-convenience was just out as a matter of law, and that Pahlavi is a sui generis exception that doesn't apply at all to this sort of case, well then, frankly, I'll get over my jurisdictional hang-up. I will not complain about that
I'm
result.
sure you understand this, but let me explain my confusion. Sorry, over
Judge
here.
Wilson.
Thank you.
My understanding of your jurisdictional point is that if the court lacks jurisdiction, it can't rule on forum non. It simply has to dismiss. This is a question of the power of the court. Yet here you're asking us, your hierarchy, your first preference is for us to skip by the jurisdictional question and rule on the forum non, which seems to me, if you're right about the first question, we can't do. And if we do what you would like us most to do, we are, at least by implication, either saying we have the power or we don't care whether we have the power or not. And I'm having trouble putting that together.
I'm to be perfectly honest, Your Honor, I have trouble too. It is a messy situation. I do not purport to know whether whether this matter of judicial power can be eliminated by my consent to a particular result.
Well, Mr. Smith, could we, under 327, under the language of 327, consider the impact of other factors that weren't considered in prior case law in the court? And specifically, the language of 327, as I read it, refers to substantial justice and a just result. And that seems to encompass the full equitable powers of whatever court is hearing the case. Does that offer an avenue for the court to address some of the contradictory complexities in the case?
Perhaps it does, Your Honor. Perhaps it does.
How so? What would you advocate?
Well, if obviously it would have to depart to some degree from Ehrlich-Bober to reach that conclusion, I think. Ehrlich-Bober does suggest that it's a matter of power. My adversaries are arguing that you should just overrule Ehrlich-Bober. I've pointed out that even so there's a problem. Even if you adopt Sign-Maritz, there's a problem, because Sign-Maritz left open a case like this case in which you can't get all the defendants in the foreign forum. And that's a even under the federal rule, there might be a problem with judicial power. However, I am receptive to the idea that 327 confers plenary equitable power to reach a just result.
If we reach that, would we, for instance, consider factors like the Heir Act, which I understand were argued below, and I'm not sure what was preserved in front of us or not by you on that argument?
It was preserved, Your Honor. The public policy was preserved in the, it's at 568 of the record, where this is before the Heir Act was enacted. But the brief says United States, the critical importance of the well-known United States and New York public policies as to stolen art. And the Heir Act was later specifically called to Justice Friedman's attention. So I don't think there's a preservation problem. I think and I do think those are absolutely critical.
Counsel, can I ask, what does the Heir Act have to teach us about forum non-convenience? Because I thought it was a statute of limitations law.
I think you have to understand that the forum non-convenience argument is an argument for sending this case to Switzerland, where there is a time bar, or at least my adversary says there's a time bar, and the time bar is absolutely essential to this case. Under the Heir Act, there is no time bar. In Switzerland, there may very well be a time bar. I'm saying that's sufficient as a matter of law to render the Swiss forum inadequate. And the complex issues that the lower courts saw, said, oh, there's these terrible problems of foreign law, all the opinions are abstruse. They're talking about the documents that were created before the Heir Act existed. The Heir Act simplifies things enormously, and what also simplifies things enormously also after the case was submitted before it was decided was the German appellate decision, which essentially knocked out my adversary's only argument on the merits. There's no question about who the heirs are here. I'm representing 11 of them. The German courts have rejected the idea that the foundation is the heir of Norbert Levy, and the only thing left is the theory that these paintings escheated to these two Swiss jurisdictions because Margaret Kiner died without heirs. Well, she didn't die without. I'm here, standing here, representing 11 of them. They'd have to prove my 11 clients don't exist, all 11. So there's really no issue.
Well, I thought there was more complexity. I thought that Norbert's will had a provision that if his daughter had no direct descendants, that it's a provision that wouldn't be allowable under American law, but I assume it's still allowable under German law at that time.
Well, the German court said, no, the German court
said... She had no direct descendants that went to this foundation.
The German court rejected that. The German court tossed out the appellate court, the appellate decision rendered in December of 2015.
But the problem for you is that the foundation is a Swiss foundation, not a German foundation.
Yes, but the foundation has no claim to inherit from Norbert Levy under Swiss law. That's a German law question. They have not challenged in any way the German decision, and they're not claiming in Switzerland as the heirs of Norbert Levy. The heir of Norbert Levy is out of the case since December of 2015, sorry, not quite that long ago. They talk very generally about, oh, well, there's such complicated questions about who the heirs. No questions about who the heirs are. They're my 11 clients, that's all there is to it. The question is whether they're time barred. They are there, they're not here. That's all there is to the case, really.
Counsel, doubling back to something that I think one of my colleagues was asking about, your representation as to what the holding is in Ehrlich-Bober.
Yes.
If we were to disagree with your representation, is there any other binding precedent that you're aware of that we can look to?
Binding precedent on that issue other than Ehrlich-Bober? Not that I'm aware of, Your Honor.
Okay, thank you, counsel. Thank you. Counsel?
Good afternoon, Your Honors. May it please the Court. Despite, as Your Honors have noted, despite plaintiff's position in the courts below, the parties seem to agree that the courts do have the power in the appropriate case to decide the forum nonconvenience issue before definitively deciding that it has personal jurisdiction. The Ehrlich-Bober case on which...
Can I stop you there?
You may.
If we assume what you're saying is correct, are we in essence adopting the Supreme Court's decision in Sign-Maritz?
I think Your Honors should adopt the Supreme Court's decision.
No, but I'm asking you, if we do that, if we follow that, are we implicitly adopting it?
You are implicitly adopting it. There is no possible way that you can do what the plaintiffs are asking to be done here without deciding that the courts do have the authority to decide forum nonconvenience before deciding personal jurisdiction. Ehrlich-Bober does not hold as a matter of law that the courts cannot do it. It was dicta in Ehrlich-Bober because it was not necessary to the court's decision. The court denied both the personal jurisdiction motion and denied the forum nonconvenience motion. It did not present the case that we have here. If Your Honors look back to where the statement comes from in Ehrlich-Bober, it comes from a footnote in the appellant's brief in that case. The appellant cited for their argument the Gulf oil language that Justice Ginsburg in Sinochem says does not stand for the proposition that the court may not decide forum nonconvenience first. Gulf oil, just as Ehrlich-Bober, has some confusing, less than carefully written language, but it is not the holding of the case. And Justice Ginsburg in Sign-Maritz quite clearly said, sure, if we have decided that the court has no personal jurisdiction, we should dismiss on that basis and go no further. The court does not say, and Ehrlich-Bober does not hold, that the court may not decide forum nonconvenience before deciding personal jurisdiction. It would be completely contrary to the whole purpose of the forum nonconvenience doctrine, which is to serve considerations of convenience, fairness, and judicial economy. The catch-22 that appellant's counsel talks about here is exactly the problem with a rigid rule that would force the court to decide personal jurisdiction first. If Ehrlich-Bober...
I'm sorry,
Sure.
I take your point on Ehrlich-Bober. I read it slightly differently. It seems to me Ehrlich-Bober is unique and not quite relevant in a couple of ways. One, I think you were getting at, which is the real issue there was comedy and whether they were going to keep the case.
Absolutely.
So preliminarily, they had to address this forum nonconvenience argument, and they were keeping it. So in the forum nonconvenience argument, they had to address both the forum nonconvenience and the underlying personal jurisdiction. Otherwise, the court wouldn't have been able to keep the case. What aggravated that to me is the appellate division decision in that case, which is unusual because it's a big dissent with a short majority that adopts kind of some of the facts from the dissenting opinion. Because again, they were talking about comedy. So in the forum argument, they kind of are playing off of a dissent. And I think what Judge Walker was doing in Ehrlich-Bober was saying, reading that, we're going to assume the appellate division found X and then found Y. Not that you have to do that all
Absolutely right, Your Honor. It really was a comedy case. It is dealt with quickly at the beginning. It's not something that the parties engaged on. Unlike this case, where the question was squarely presented to both lower courts, can the court first decide forum nonconvenience, or must the court first decide personal jurisdiction? It was squarely presented in this case. It was not squarely presented in Ehrlich-Bober at all, Your Honor. It was mostly a comedy case, as you said. I want to address the Heir Act for a moment. I don't think this court has the ability to rebalance the factors, to rebalance the considerations that were argued below. That's not this court's job. The abuse of discretion standard commits the decision on forum nonconvenience to the courts below. Here we have clear, careful findings from both the trial court, the motion court, and the appellate division on some of the most, the relevant factors. Where are the witnesses? Where are the parties? Where are the documents? What law is going to apply? The court balanced all those factors. The court was presented with the Heir Act argument, at least in the appellate division.
Let me ask you this, though, on the factors. I think you make a fair argument, and I don't know if I agree with you, but it's a fair argument. It's a reasonable argument. But it seems that we're confronted here with some of the consequences of what is arguably the greatest crime in human history. And in that situation, are we limited in applying what we consider substantial justice to the lower court's specific balancing of factors that we may personally disagree with, but doesn't seem to have balanced or have been able or felt that she was able or he was able to include that kind of a factor in the same way that the Heir Act would have included that kind of factor in balancing the justices and reaching substantial justice. Aren't we required in that circumstances to reach outside kind of the constrained, constipated jurisprudence that seems to hold back an examination of the principles of substantial justice to a very, very unique situation? Aren't our constraints somewhat different here than they would be in another case?
I don't think so, Your Honor. The courts below were presented with these arguments. At least the appellate division was. The Heir Act was not argued in the motion court as a ground for keeping the case in the United States.
But my argument is based a little bit broader than that. It's based on the language in 327 itself, which talks about substantial justice and reaching a just result. Anyway, you go ahead.
Reaching a just result also requires consideration of the important considerations of forum nonconvenience. That is an important consideration
Right, but
of the New York
convenience-
courts, to not be
The
forced.
language itself is revelatory. We measure convenience against justice. Justice is always going to win. We'd all agree with that. So does the inconvenience reach a point where you can't have justice? That's what we have to look for, right?
Perhaps in some case that is right, Your Honor. But justice also requires that we be able to, it's not just convenience, that it would be unjust to require litigation of this case in this court, in the New York courts, because it hinges on what people did in Switzerland and Germany and France years ago. We could not compel those witnesses to be here at trial. We are faced with a situation where there could be conflicting rulings of Swiss courts that are deciding the very same remedial relief that is sought here, namely an award of damages related to the painting and the other assets of the Heir estate. It is unjust to force this case to be litigated in New York. I understand the concept and the principle that the courts of the United States and New York want to give the ability to remedy what is a grave injustice of historical proportions. But that's not really the question that's to be asked. Is litigating this case just, convenient, and efficient to be done here in the United States? And I think the answer to that is no. And even if you thought that, Your Honors, if you thought that there was a factor that the lower courts did not properly consider, the right outcome is remitting it to the appellate division. CPLR 5613 says as much, that if this court concludes that the lower court failed to consider something that it should have considered, it shall remit to the appellate division for further consideration. Now, I don't think we need to get there, Your Honors, because the lower courts did consider these arguments. The argument that it was somehow overlooked is inconceivable. It was a linchpin of their argument in the appellate division. The court below said, we have considered plaintiffs' remaining contentions and find them unavailing. The argument here is, well, that's boilerplate. But that's really an accusation that the appellate division didn't do what it said it did, namely consider the other arguments. There's no requirement that the appellate division go point by point by point by point through the appellant's brief and rebut it. And even if you thought it had been overlooked in the initial decision, they moved for reconsideration on the ground that the court had overlooked it. And the court denied that motion, indicating that, in fact, it did not overlook it, because had it overlooked it, it would have granted reconsideration and done what it needed to do. Thank you, Your Honor.
Thank you
Thank
for
you,
your answer.
counsel. Counsel, your rebuttal?
Yes, I think the main point to make, Your Honor, I don't view this as a balancing case at all. My point is that we have a forum in Switzerland that is inadequate as a matter of law, because there are very grave impediments to reaching the merits. Indeed, the only defense he has is don't reach the merits, because he doesn't have any defense on the merits. That's why he wants to go to Switzerland. Where there is such a situation, I'm suggesting to Your Honors, as a matter of law, a forum non-convenience motion may not be granted, because you may not send a case to an inadequate forum unless you have the sui generis Pahlavi situation, where the Islamic Republic of Iran was saying, oh, please don't send me to the Islamic Republic of Iran. Their courts are all in turmoil. And this court said, in effect, give me a break. It's your courts. But to take that as carte blanche, as perhaps some lower courts have, to say, oh, we don't need to worry about the adequacy of the foreign forum. That's just one factor we can balance away. And we balance it away by saying we've considered your other arguments and they lack merit.
But counsel, isn't choice of law one of the issues that would have to be decided in the New York court were this litigation to go forward here?
The choice of law issue on the time bar is easy, Your Honor. The Heir Act chooses the law for you. There's no statute of limitations bar. On the merits, the only really debatable issues relate to Christie's role in the auction in New York, to which New York law should apply. And yes, they would have that choice of law decision, but I think it's a choice. I think it would be made in favor of New York. Speaking of the choice of law, I want to refer Your Honors to the Second Circuit decision by Judge Corman in the Bacalar case in 2010, which explained how a choice of law decision can be informed by the contrast between the Swiss court policies, very hostile to the claims of Holocaust survivors, and the New York policies favorable to those claims, and that should impel a court to choose New York law. I would say that by the same token,
Well, it's not just Switzerland, is it? I mean, we have France, there's litigation there, there's litigation going on in Germany, I think, you know.
not anymore, Your Honor.
That's over now?
No, the only litigation is in Switzerland and here. We won in Germany, and his defense disappeared when we won in Germany. I think the problem is that happened, and the Heir Act was passed while the case was sub judice before Justice Friedman, presumably when she's already working on her opinion. And she does talk about the Heir Act, and she does talk about the German appellate decision, but she talks about them as afterthoughts. I'm suggesting that they're central, that they simplify and transform the case, and that they make it impossible as a matter of law to send this case to Switzerland, because all you're doing is sending it to a case that's going to hinge on a policy absolutely contrary to the policy of the United States and the policy of New York, and that's error as a matter of law. It's not balancing.
Thank you, counsel. Okay, at this point in time, the court will stand in a 10-minute recess in order to execute our cleaning protocols.
All right.
Okay. This is Appeal Number 77, the people of the state of New York versus Lamb. Counsel?
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Michael Lamb. May I reserve 2 minutes for rebuttal?
2 minutes, sir?
2 minutes, please.
Yes, you may.
May it please the court. The court below erred in its interpretation of the sex trafficking statute. That error affected the resolution of 2 critical issues at the trial. First, the court erred in holding that New York had geographic jurisdiction to prosecute Mr. Lamb for trafficking Jasmine C. And second, the court erred when it answered a jury note and told the jury that the people were not required to prove that Mr. Lamb advanced prostitution by trafficking a specified person. The actus reus...
Counsel, I'm
Sure.
sorry. Is part of your argument, at least, is that this is a one-element crime? Is that right?
I don't really think it's correctly characterized as a one-element
Okay.
crime. I would agree that there are multiple things that the people have to prove. They have to prove that my client profited or advanced prostitution, and they have to prove that he did so in a specified way through specified coercive conduct. But the statute links those elements by use of the word by. And so, yes, there's more than one element, but that one element is tethered to the other element. So it's not a standalone element.
I understand that argument. So would you, and I know there was no objection at trial, would you agree that the initial charge was correct?
The initial charge was correct, yes.
So your position is it was the supplemental charge that undid the original charge?
That's correct. The initial charge, which followed the CJI,
Now-
was correct.
What if, and I know this isn't the case, but let's say you flipped the conduct here, right? So you had, let's call them the threats for shorthand, in New York, and you had the other activity in New Jersey. Could you charge it to say, during the relevant period, the defendant advanced prostitution and profited from prostitution, and that he did so by threatening this person in New York? Would that be okay?
Threatening the person in New York with the goal of coercing her to
Yeah, whatever
be
the
a
language is in
prostitute
Part
in
B.
New Jersey, then yes, I do think that would be sufficient, because the intended result was, he manifested his intent, his criminal intent, to promote prostitution in New York in New Jersey, by
Right.
the threats in New York.
Okay.
So is your argument that someone could never be prosecuted, or we can never find jurisdiction for threats that occur outside the state if someone is advancing an enterprise in New York State? Or you're just saying in this particular case, because of that bridge between the 2 parts of the charge, haven't been met? I'm just trying to understand your argument.
Right, so I would never say never. There needs to be proof of a connection that the threats were for the purpose of inducing the end result in New York, which was the prostitution.
So it's not the fact that it was out-of-state conduct per se, it's the fact that you think the people failed in establishing that connection.
Correct. If they had shown with proof, that his intent was to force Jasmine C. to become a prostitute in New York State, then that would have been sufficient. But there was no proof whatsoever that was the intended result.
Well, it seems more, counsel, though, your argument, that to me sounds a little too much like a sufficiency argument. I understood your argument to be the instruction itself the supplemental instruction disassociated the parts, so they didn't need to find that, right?
Well, there are 2 separate arguments. There are 2 separate errors here. There's the geographic jurisdiction issue as a pure question of whether the people proved the sufficient connection. And then there's the second issue when the court responded to the jury note telling them that the two elements didn't need to be linked. That was not a meaningful and accurate response to the jury's question.
But you're not making a legal sufficiency argument, are you?
Well, I think geographic jurisdiction and legal sufficiency, there was not sufficient evidence of jurisdiction. So to that extent, it is a legal sufficiency argument.
So it's your argument that we have to, in essence, adopt Judge Titone's dissent in Giordano. Is that what you're saying to us?
Well, I have
I'm
trouble
not trying to
with
trick you or trap you. I understand it's always reluctant. Anybody would naturally be reluctant to argue, but it's some of the analysis.
Well,
anyway.
I think that's a more correct analysis. I don't
Mm-hmm.
think that the court has to find that Giordano was wrongly decided. Giordano was a venue issue
Mm-hmm.
for one, and this is a geographic jurisdiction. One deals with just a choice of counties. The other deals with the power of the court to prosecute. And the other is that there are significant differences between the promoting prostitution article, Article 240, and sex trafficking on the one hand versus the promoting gambling article on the other. Promoting gambling in the first degree, which was at issue in Giordano, was an enhancement offense. It was an enhancement of the base level of promoting gambling. As we argue in our briefs, sex trafficking, it stands totally apart from promoting prostitution, which is the corollary to Giordano. For example, there are other promoting prostitution offenses. There are a range of them with different levels of severity based on the conduct, including promoting prostitution in the second degree, which penalizes advancing prostitution by compelling a person by force or intimidation to become a prostitute. I mean, that's the enhancement offense. That's the corollary to Giordano.
It seems, though, that there are, I, in my mind, identify three specific public policy implications of what you're arguing, or at least what we should look at. First being the validity of the precedent itself in Giordano. The second being how that would affect the limits of state jurisdiction in our analysis of the elements. And the third being the practicality of policing in an environment where it's totally different from Giordano, and in an environment where communication is almost instantaneous and limitless. How does one police that environment with the kind of, in many ways, impractical analysis of arbitrary lines as controlling the policing powers of the state over particular activities. So those kind of activities, it all kind of fits in within that. And I have to admit, I'm a little lost in saying that we should separate the jurisdictional analysis from the jury note analysis, because it seems to me that they rise or fall together. So those are my problems with it.
That's a lot to answer.
I know. So pick your poison.
Let me
Go ahead.
start with the policing aspect of it. I mean, the answer is that cooperation between, state police offices is the answer to this. New Jersey's right next door. New Jersey could have prosecuted this as sex trafficking. They have their own sex trafficking statute. These actions took place between New Jersey citizens in New Jersey. So a phone call might have been the easy answer to that. And I see my red light is on, but if I could just for a
Yes, you
a
may,
minute.
sir.
In terms of the linkage, they are certainly linked. That the by means, is a limiting causal word. It creates a causal
Well, that's what I was
connection.
thinking. Not necessarily, forgetting about how you come out on it, it seems to me that it's very hard to separate those two issues in any legal analysis. If we give an instruction on jurisprudence, and it's a factual question, then we clearly is going to bleed into the jury instruction.
Well, they bleed together, Judge. They really do. But one is finding one is working. We're sort of compelled to work within the framework of Giordano, to some extent, on the jurisdictional issue. But one is a simple causation question. The statute, and that's the jury note answer.
But you see what you're arguing. We'd have to say by means one thing on the jurisdictional issue, but it means something else when we get to the jury note. That doesn't make a lot of sense to me.
Well, I agree that the plain meaning of by in these circumstances seems very clear to me. It says you promote prostitution by a threat. You have to prove that connection. You have to prove that the threat promoted prostitution. To me, it's not complicated. Giordano, I agree, complicates the analysis.
Yeah, but for jurisdiction, why is it not simply in a multi-element charge? If one of the elements was in the jurisdiction, then you are allowed to prosecute it. I mean, are we really saying that when confronted with a trafficking operation in New York, we should pick up the phone and call New Jersey and ask them to prosecute it for us?
We are saying that if the language of this statute requires that you promote prostitution by a particular action. So you can't just say an element occurred in New York. Yes, there was promoting prostitution in New York, and we don't contest that, but the statute as drafted requires that you promote prostitution by a particular action. You know, there are a range of types of threatening conduct here, some of which are not even illegal, some of which are not even tied to prostitution that are covered by this statute. For example, withholding a passport. So if somebody withholds a passport in New Jersey for unconnected with trying to promote prostitution, for example, and they also promote prostitution in New York, by your suggested reading, you could prosecute them for sex trafficking in New York because one of the elements occurred in New York, and that the statute just doesn't permit that. It wasn't designed for that purpose.
But I think that goes back to Judge Garcia's point that it's more like a sufficiency, because then the answer is maybe that's a not guilty or maybe that's a trial order of dismissal, but not that there's no jurisdiction, because if there was the connection, would you agree that there would be jurisdiction?
If there was.
If the people had adequately connected the coercive action with the operation in New York, would there be jurisdiction in New York?
Yes, because then the by would operate correctly as it's intended in the statute.
So that it is more sufficiency than jurisdiction.
Well, again, sufficiency of proof of jurisdiction. And yes, we have to interpret what the word by means to determine whether there was sufficient proof of jurisdiction.
Hypothetically, if the defendant here had said, I'm going to tell your father all about this unless you show up at this address in Manhattan on Tuesday night, that seems to satisfy the by requirement.
It would.
So jurisdiction would be present in that scenario.
If the by was satisfied, correct, I agree.
Thank you, counsel. Counsel?
Good afternoon, Your Honors, and may it please the Court. John Hughes for the people. New York has jurisdiction if any element of a crime was fulfilled here. And in this
Counsel, let me
case,
ask you on that point.
Yes.
So let's say the defendant has the same type of operation as this case in New York. It's a multi-state kind of recruiting in Jersey, whatever. And then he goes to California to visit some friends, and they have their own operation out there. And they say, you know, we could really use your help out there. You're good at this. You know, could you go out and help us with this one person we really want to threaten and coerce her into becoming... And he does that. And they say, thanks a lot, you really helped us out here. And he flies back to New York. Do you have a sex trafficking count in New York?
under those facts, I think probably not. And there's one thing I want to clear up here. Our position is not that, you know, the elements of this crime can be completely unrelated to one another, like in the example you gave. You know, I would say that these, statutes have to relate to one another in one sense. Just that as long as the coercive acts, as was proven here, are meant to further the same multi-state prostitution enterprise that we proved that defendant was running in this case,
And
that's sufficient for jurisdiction.
Why didn't the supplemental instruction sever that requirement?
Well, as I understand, defendant's objection, first of all, the jury note was simply asking about whether the element 1 for advancing or profiting from prostitution has to relate to the same person as the person who is the victim of the actual coercive acts that's described in element 2. So that was really the only issue that the court was responding
But
to.
it seems like with that supplemental instruction, a jury could convict a defendant of sex trafficking in New York under my hypothetical.
Well, here, Your Honor, first of all, I think we absolutely proved that that defendant's prostitution enterprise was meant to be furthered by the course of acts that he actually committed in this case, with which he was like threatening the victim. So here I think.
But that's a harmless error kind of analysis, right?
Well, I don't
I
think
mean,
there was
that's
a
a bad charge, but it's okay because they would have had to find this anyway, kind of.
Well, in the first
argument.
place, Your Honor, the defendant did not raise any objection to the initial charge
Right.
when it was charging these elements. And the later question was really only about does element 1 and element 2 have to pertain to the same person? So, first of all, the defendant has not preserved any claim about whether the elements were properly charged to the jury in the first place.
So to take your adversary's argument, what does by mean in the context of this statute? Since I take you to state that there doesn't have to be that personal connection between the promotion and the harassment or threatening, whatever it's referred to as. What is by in the statute?
Well, actually, in 2019, when this court decided People v. Roberts, the majority noted that the word by, this preposition can mean many different things in different statutes, depending on the surrounding context.
Okay, what does it mean here?
Well, here I think it simply suggests that the coercive acts need to relate to the prostitution enterprise. That's the subject of the advance or profit from prostitution that constitutes element 1. And also, I want to turn back to Giordano for a
All
minute.
right, so counsel, if I can just clarify now your position, because I think I may have misunderstood your briefing on this. It strikes me that you're now arguing that there's jurisdiction as long as there's profiting in New York, right? That gives you your jurisdiction because you're saying that that's a separate element, but that actually he could not have been convicted if you didn't connect the conduct in New Jersey to that, let's just use profiting for the moment, profiting from prostitution in New York. Is that your argument?
Yes, we're saying that as long as these two elements, have that kind of relation where the coercive acts are meant to further the prostitution enterprise, then that is sufficient, and we think that was sufficient here in this case.
No, but okay, so then why isn't defense appellate counsel correct that it really is then the by links these different ways in which the defendant would indeed commit the crime of sex trafficking as defined in the statute?
Well, as this court
It
found,
strikes me it strikes me that you are now agreeing with his interpretation of the statute, but your position is, but we showed that link, and his position is, you didn't show that link.
So I'm sorry, if you give me a moment, Your Honor. The important point here is simply that the word by does not collapse two elements into one. And that's really what's at the heart of this jurisdiction claim, is how many elements the sex trafficking statute actually has. And that's the question this court already answered in People v. Giordano.
But Giordano, because it is about venue, works from the assumption that all conduct, as was the case there, is occurring within the borders of New York State. The prosecutor wasn't relying on conduct outside the borders of New York State, which is what's going on in this case. Strikes me that you have a real constitutional problem if you're doing what Judge Garcia described in his hypothetical.
Well, I don't think so, Your Honor, because People v. Giordano is important because of its statutory interpretation principles, not because it involved venue as opposed to jurisdiction.
Yes, but if as you mentioned, the court has already said by can mean different things in different statutes. So for the venue statute, when all conduct is within the borders of New York State, by means whatever Giordano said it had to mean. I don't know that counsel is not arguing for overruling Giordano. Doesn't seem that it necessarily needs to be overruled, given the context of the question as presented there, right? But here, because you yourself are saying you've got to have this link, then by must mean something else.
Well, Your Honor, in Roberts, when this court said that the word by can mean things in different contexts, it was referring to different penal law offenses. I don't think that crimes can be interpreted to have different numbers of elements just because the defense is challenging venue as opposed to jurisdiction. And importantly, too, Giordano, which interpreted the first-degree promoting gambling statute, was decided in 1995. The legislature enacted the sex trafficking statute in 2007. And in doing so, the legislature copied the structure and language of first-degree promoting gambling when it was writing the sex trafficking statute. So therefore, I think we have to presume that the legislature did in fact mean for the sex...
But the legislature, we have to presume, understood the constitutional limitations on the state's ability to prosecute for actions that are disconnected from, at a minimum, some consequence in New York. I mean, it couldn't possibly have intended for New York state prosecutors to drag people in. We'll just take New Jersey, since it's just, a train, car ride, bus ride, walk right away, to bring them within New York to prosecute them for actions that only occur and only have consequences in New Jersey. I mean, I would think the New Jersey prosecutors have something to say about that.
Well, Your Honor, I disagree with a premise of that question, which is that this case, in terms of the amount of contacts that this case had with New York, there were many contacts with this one. Defendant was publishing hundreds of ads in New York, recruiting both patrons and sex workers. He sought to recruit young women from homeless shelters in New York to work for him as escorts. His Twitter page labeled his enterprise as Lavish Escorts NYC.
Yeah, but he doesn't dispute that. I think the issue is that the one person that he's convicted on is conduct. He argues it. I know you take a different position. I'm just saying. His argument is all of that conduct occurs in New Jersey, and it's not intended to further the enterprise in New York. So that's where he's saying that's what's missing from the prosecution's case.
Well, no, here I think we absolutely proved that by these coercive acts, he did mean to further the enterprise that was the subject of the advances or profit from prostitution. Element one of the statute.
Can I switch you over to a different subject? I wanted to have you address for a moment or two the pro se brief, and particularly the question as to the sufficiency of the indictment and the bill of particulars. So at least as I see, even after the bill of particulars is answered, what the defendant gets is timeframes that are about a year long as to when the conduct might have occurred, April 1st of 2014 to April 30th of 2015. And all the bill of particulars adds is a location, New York County and elsewhere. So if you imagine that the defendant here is running some sort of big prostitution ring in New York, and the purpose of both the bill of particulars and the indictment is to give him, among other things, some ability to know exactly what he's being charged with, how does he know what this is about? How is this sufficient?
Well, Your Honor, I think like this court's decision in D'Angelo, and if you look at the practice commentaries to CPL 200.50, it's clear that for facial sufficiency purposes, it's enough for the indictment to simply include the statutory text, obviously include some timeframes, and supplement that with other details as needed in a bill of particulars, such as here, where the bill of particulars informed defendant that, for example, there were multiple victims. And note, too, that the trial court also...
It didn't even say New Jersey. It said New York County and elsewhere. So, I mean, that might even mislead him, right? He's got a bunch of prostitutes working for him in New York City. This is a year-plus time period. How does that tell him that it's these two that are at issue?
Well, Your Honor, first of all, his enterprise was definitely a multi-state enterprise. He characterizes it as the entire tri-state area. But more to the point, I don't think that there is any requirement that an indictment needs to allege every single county.
How about the bill of particulars? Isn't that supposed to give him information that's not recited in the indictment and which pertains to the offense, including the substance, for the purpose of letting him know what he's charged with and being able to prepare a defense?
Well, again, Your Honor, I don't think there's any requirement that if a criminal offense involves multiple states, that every single one of those states has to be mentioned in either the indictment or the bill
And
of
so
particulars.
so when you're prosecuting for acts, for conduct that essentially occurred in New Jersey, the bill of particulars is fine when it says New York County.
Well, yes, because here, again, he ran his prostitution enterprise in New York. He even told people it was based here. So I think this absolutely gave him fair notice of the nature of the allegations against him, the time frame that it involved. And furthermore, there's simply no indication that he was actually deprived of any kind of fair notice. He put on a vigorous defense at this trial, and there was simply no indication that he was at all confused about what the allegations against him were.
Thank you, counsel.
Thank you very much.
Mr. Ziano?
I'd like to return to the geographic jurisdiction and jury note issue. We've talked about what the word by means in the statute and what it meant in the jury instructions. It seems as though the prosecutor's argument is that by here means and, that a person is guilty of sex trafficking if they promote prostitution and commit a threatening act. Not by. The statute doesn't say and, it says by. While I agree by can mean different things in different contexts, that it doesn't mean and here. There is a statute promoting prostitution which covers these crimes. My client was convicted of that crime, but by untethering the promoting prostitution and the threats and telling the jury that my client could be found guilty if he promoted prostitution and made threats rather than promoted prostitution by making threats, the court just changed the whole nature of the offense.
Thank you, counsel.
Thank you.
Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in the State of New York, may depart hence and appear here Thursday afternoon at 12 o'clock, which time this court now stands adjourned.